Hello folks, welcome to the Edupedia world and I am Abhinay Gupta. Today again we'll continue with the topic, the appointment and qualification of directors. In our previous lectures, what we have covered is basically in the past two lectures if I'm talking about, we have covered the small shareholder directors, the provisions related to the small shareholder directors, their position in the company, the limitations on them, the requirements, the necessities, the qualifications. We have discussed these topics in the preceding lectures, and in the just previous lecture we have discussed about the data bank of the independent directors, right? So we have discussed about section 150, the provisions of the act, and also we have touched upon and understood the rule 6 of appointment and qualification of directors, rules 2014, right? So we have had a detail of insight into it. Today we'll move ahead to the next topic, that is about the additional director, section 161 subsection 1, right? So here now we'll understand the provisions of section 161 subsection 1, which is related to additional director, and for that we need to first understand who are additional directors, right? And then we'll see about their appointment, their office, their qualification, disqualification, resignation and stuff, right? So first we need to understand who are additional directors. So who are additional directors? Obviously directors who have been appointed into the board additionally. So yeah, so if we go by the layman term, if we understand as per its cognate sense, in its alphabetical, in its vocabulary sense, so additional is an extra director, right? More than what you already have, more than what was required for you. These are not a very normal phenomena, and these are not permanent directors into the company. And these directors, the most important thing is that these directors are not appointed by the shareholders. Additional directors are appointed by the board of directors, right? And this is the discretion of the board of directors at any point of time when they think that they need an additional director for proper functioning of the company, or if there is something they are not able to handle, they need a person who has an expertise in a different field, so they may go for like appointing an additional director, right? And when we talk about additional director, if we again go back to understand the provisions of section 152 subsection 6 and 7 about the rotational non-rotational director, we saw that there is 2/3 of the total number of directors should be rotational. So when we talk about total number of directors, we have seen that only independent directors and the nominee directors would be excluded. So the additional director would be included in the total number of directors, right? So now we have seen that board has a discretion to appoint additional director, but is this power vested upon the board by the act, by section 161 subsection 1? The answer is no. Yes, it is a little shocking to understand, but section 161 subsection 1 does not vest the power upon the board to appoint an additional director. Now there is a confusion in your mind that I just said that section 161 subsection 1 we deal with the additional director and they are appointed by the board, and now I'm saying that 161 does not give the power to the board. Exactly. Why I'm laying a great detail of stress on this point is that you should always remember that these powers are vested upon the board by the article of association of the company. So section 161 subsection 1 allows you to appoint an additional director, but the power to appoint additional director vesting upon the board is given by the article, right? So you should have both of it. So act allows you to have additional director, article gives you the power. So when both combines, you appoint an additional director into the board. Otherwise you are not able to do that, right? So that, I think that is very clear with you now. Now if your article does not provide, if you have not given any specific condition after appointment of additional director in your article, then again you can apply the models of table F at any point of time. So for additional director also you have a model of table F available, that is regulation 66. So regulation 66 of table F authorizes the board to appoint the additional director, right? So by this time I think you are familiar with what table F is, right? So table F is basically a model article. So if there is something not referred in your article, if you don't want to give an express provision for the same, you can pick up the models from table F. Like regulation 66 is about giving you the power for additional director. So there are various regulations in the table F that can be directly applied into your company, right? So even going forward, when we talk about the casual vacancy and stuff, we'll understand whether we have a model in table F. Like if I break the secret now, we don't have a model for filling up the casual vacancy in table F. So we'll understand what are the models available, right? And this will be very important, because when you have been reading, like basically the students, as a student when I was studying law for the first time, I never used to pay attention on this regulations and table F and stuff, because I thought these small little details will not be retained in my brain. If I know the provision, that is more than enough. Learning the section is a headache, and learning these regulations is a double difficult task. But my dear friends, once you start understanding what these regulations are, what does table F mean, right? So you understand that yes, these are modules, and you will understand the location where these modules are applied. So once you have that map in your mind, it becomes very easy to understand and memorize the regulations. And memorizing a section is again a very easy thing. Whenever you start reading to your chapters, always start with browsing through the sections. Just take a glance at the sections every time you open your book, and then start a topic. I tell you, it is very easy to memorize the sections. And yes, we know that you don't fetch marks per section in the examination. This is the disclaimer of the institute. But my dear friend, the examiner who is checking is a human being, right? And you create a psychological impact on that person when you quote the right section, because that always gives an impression that your answer is correct. You know the provisions, you know the sections. That means you know the provisions inside the section, right? So that will always give you an upper edge, although it doesn't fetch you an additional marks, but overall it will impact a lot while the checker is checking your answer. He may skip on some of the provisions, deeming a fact that yes, you might be knowing it. But if you don't write the section, he will have to go into detail with everything, and then again at the end, if he misses out on some point, you lose marks for that. But my dear friends, remember, it's a word of caution that if you don't know the section, please don't try guessworks, because a wrong section quoted in an examination would take away the entire marks from that question, right? Okay. So now let's get back to the additional director. I hope regulation 66 you understand and you know it. But there is one more limitation when we talk about the additional director. That is, those directors, right, whose appointment was put in front of the members in the general meeting for election, but he failed to be appointed in the general meeting. So that person cannot be appointed as an additional director by the board, because the shareholders don't want him to be in the board, so they didn't approve him initially when he stood for election as a director, right? He was not appointed then, so the board will not be given a power to elect that particular person who has already been rejected by the shareholders. Now, when the board is electing a director, so we already know that board has two ways of passing a resolution, either holding a board meeting or resolution by circulation. So are both these methods, both these modes of appointment open to the board in case of additional director? That is a question, and the answer is yes. So let's take it this way. Appointing an additional director is a very casual matter, very casual affair for the company. So at any point of time, the board of directors think that yeah, we need an additional director. So it is their discretion. They can appoint an additional director. If they can hold a meeting, they can. If they can't hold a meeting, float a circulation, and then get a resolution by circulation passed. And if it is passed, get the director on the board. Right? So it seems to be a very casual affair. Right? There are just little small things that you need to pay attention to. Otherwise, an additional director, an appointment of additional director is a very casual affair. Right? Next, what we need to understand again over here is the term of office for the additional director. So any additional director would be appointed because he is not replacing anybody. So we won't link his appointment to any person else's tenure. He will have his independent tenure. But that won't range for a year or 2 years or 3 years. That will be just up to the next AGM. Right? So since it is a very casual affair and it is a discretion of the board, they can hire an additional director at any point of time. Hire one and let his tenure end by the next AGM. If again you need a director, you feel that you need a director, hire another. Again, his tenure would end at the upcoming AGM, right? But if the AGM is not held on due date, then that additional director would have to vacate the office on the last date on which the AGM is due to be held. So that would be the time when he will have to vacate his office. And he is not a resigning director. Please keep that thing in mind. He is not going to get the benefit of resignations. He is not going to get anything related to resignation. He has to vacate the office. And if he wants to get reappointed into the board as a normal director, right, then he will have to give his application for appointment into the board as per section 160. Right, we have already dealt with section 160. That is, if any other person wants to get appointed into the board, what are the procedures he will undertake. Right? So he will have to follow the provisions of section 160 to get appointed into the board on permanent basis. Right? Now, when we talk about additional directors appointment being a very casual affair for the company, so do you think we take this additional director for granted? The answer is no. Although the appointment is a casual affair, but his position into the company is as equivalent, is parallel to the other directors in the company, right? So he would have the same rights, same power, same duty, same liability as any other director in the company, right? And also the provisions that are related to the disqualifications, the grounds of vacating the office, the disclosure of interest provision, all such provision would be applicable on an additional director too, right? And one more thing, when we are talking a lot about casual, just remember he is not casual. It is not necessary that we will always appoint him as a non-executive director because we want somebody for some specific thing. Let's call somebody and he's a non-executive director and he'll vacate office by the AGM. No. You can appoint an additional director as a whole-time director, as a managing director, as any director, right? And that will be done as per the genuine provisions of the Act. As we appoint the other directors, we'll appoint him that way. We'll give him the position. He can be a managing director too. So we should not be underestimating this director. The affair is made casual for the benefit of the company. We should not complicate all the things. For appointing this, we need somebody in the middle of the year to run the company, to help the company, to support the company. We will not be waiting for the meeting of the shareholders. We will hire him then and there and will give him the position of managing director if that is needed. So he is not a person to be taken lightly, although appointment is made casual. That is made for the benefit of the company. So you need to understand this, right? So now I think you know who an additional director is and what are the procedures following him. Now the concept is clear, right? Now he is not just an additional director. He is a person to the company, right? And we've already seen he would be included in the total number of directors, and we can hire him only when the limit, the ceiling of the number of directors allow us to do that. If you already have 15, you cannot appoint an additional director unless and until you extend the limit by passing a special resolution and by amending your articles, right? So he has all the rights and he has the same position as the directors. So this was a deemed provision that I guess you should have understood before me telling that, right? Now we'll understand some of the questions that have been asked in the previous examinations, although this is not a very frequent topic, right? But you may expect a question on that, right? So let us discuss some of the questions that have been asked in the past. So we'll first pick up CA Final May 1996 question, right? So what did the institute basically ask in the question? So the topic was that the AGM was not held on the due date, right? So the question asked, can an additional director continue his office? Because if we go back and understand the provisions of section 152 subsection 6 and 7, when we talked about rotational, non-rotational retiring director, over there, if the general meeting AGM is not held, we know the retiring director needs to vacate. But if it is held and adjourned and then it is not expressly provided, he would continue till adjourned meeting and so, and if over there also no other person is appointed and it is not expressly provided as not to appoint, he would be reappointed, blah blah something, if you remember vaguely, right? We had such provisions when we were discussing that section. So will that apply on the additional director? The answer is no. We have already seen he is not a retiring director. Those provisions will not be applicable on him. Right? So he will have to vacate the office on the last date on which the general meeting, the annual general meeting was ought to be held. There is no other provision for him. Right? But the question goes ahead to give a twist for you. The question asks that will your answer be different if M was also appointed as managing director for the period of 5 years with effect from whatever date? So what do you think now? If he was also appointed as a managing director, right, and the appointment specifies he was appointed for 5 years, will that be applicable? Will that be eligible? Will he be eligible to continue for 5 years? This is a question that you need to think. I would have given you some time to think, but if you want to think, you can pause the video at any point of time, right? I'll continue with that. So, who is a managing director? If we see, any person who is a managing director first needs to be a director. But after the last due date of AGM, the additional director fails to be a director. So if he is not a director, he is no more a managing director too. Hence, he needs to vacate the office. Right? And if he is re-elected, if he wants to be re-elected as a managing director, he will have to follow the provisions of section 160. We have already discussed that. And as per section 160, that is the right of person other than the retiring director to stand for directorship. Because he is not a retiring director, he is other than a retiring director. So his rights to stand for directorship lies in section 160. We have discussed it in detail in the previous lectures. If you still have a confusion, please go back to the lecture, refer it once again and come back. Right? So, the next question that we had in CA Final November 1996, back to back. Now, what did they ask in CA Final November 1996 as well as CA Final November 2008? Over there again, the question asked the same provision. That can an additional director be appointed as a regular director? Right? So that means when he is vacating the office, can he be reappointed as a retiring director? That is what the question means. So I think you know the answer. He cannot. So how do you write the answer? First you will write the provision that the retiring director for the purpose of section 152 and 160 of the Companies Act 2013 means a director retiring by rotation. Right? That is a retiring director. An additional director is not a retiring director because he is not a rotational director. He has to vacate the office as on the due date of AGM. Right? That is what we'll write. So first we'll specify who a retiring director is, on whom those provisions are applicable. And then we'll say as to who an additional director is. And we'll specify he is not a retiring director. So, provisions of section 152 will not be applicable to him, but 160 will. And then we'll write the requirements of section 160. Right? The requirement of the entire section 160 about the right of a person other than the retiring director to stand for directorship. Right? So that is how we write the answers. Because that is very important. In the previous few lectures we have discussed the ways to write the answer. That is why I keep discussing after I give you the bullet points also. In between the lectures I've emphasized on asking you and sharing with you one or two answers so that you know how to write the answer. Right? So the next question that was asked was in May 2010. That was recently but still 10-15 attempts back. And there you had the straightforward question as to who appoints him. You know the board does. And what happens if the AGM is not held on due date? You know the answer. He has to vacate. Again, that is not enough to write that he has to vacate. You will have to write the entire structure again. Why will he vacate? He is not a retiring director. Right? He has to vacate. He is not a rotational director. You will have to specify all of those things. And if you know a case study on that, you should specify the same too. Right? So, in the question actually, the question had few parts, according to which it asked whether that person can continue as director if AGM is not held. The second part asked you whether the power of appointing an additional director can be exercised by the annual general meeting by the members. And the third question was that as a secretary of the company, what checks would you make after I am appointed as an additional director? So these were the three contents of the question. So I would like to read out the entire answer to you, to the way of presenting the answer, so that again you will understand how to write the answers. So in the first, where the AGM was not held, what you write is, first you write the provision that the additional director will have to vacate the office by the next AGM, and if it is not held, then the last due date of AGM, whichever is earlier. That is the provision we have discussed, so that is the provision you will be writing. And then you will be writing that in the given case, the AGM was not held, so on the last due date, he will have to vacate the office. It is as simple as that. Right? And for the next question, whether they are allowed in the annual general meeting, right? Then over there, that whether they can be appointed by the members, the answer is no. They will have to be appointed by the board. The board has been given the power, and the power is given to the board by the article of association of the company. That is what you will write. And then again you will give a reference to the case study. Over here the reference was given to Blair Open Heart Furnace, right? Company Limited, Private Limited, Company Limited versus Reigart, R-E-I-G-A-R-T. That was the case. I know it's difficult to remember, but that was the case. If you remember, well and good. If you don't remember, it is not a pressure, right? And then, but there is always an exception. Now what is the exception? Okay, we will first give the opportunity to the board, but if the board is not able to elect, when is the board not able to elect? If there is a deadlock, or if majority of directors are interested and they are not able to vote, they are not allowed to vote, then what do? And still you need an additional director. So in that situation, you will refer to the members in the general meeting. Right? The power to appoint additional director will be exercised by the member. Again, for that you have a case, and it is good if you remember this case, because this is an exception. And if when you mention an exception and you refer to the case study, you get full marks in your examination. So the case study was for Baron versus Potter. It is as simple, two words, B-A-R-R-O-N, Baron versus Potter. That is the case where it was an exception, right? And the third question, there as a company secretary, what checks would you have on them? So it is very simple. We'll go back to the previous sections that we have discussed. So we'll see if Mr. M is not disqualified under 164. We'll see that he has a valid DIN, right? And that he furnishes the DIN and gives his consent, and also the declaration, the three things that he has to give for his appointment, right? And then we'll see that that Mr. M furnishes that consent in form DIR2, and company forwards the same in form DIR12 to the registrar, right? And that too within 30 days. And that the particulars of M and the details of shareholding and stuff should be registered into the register of directors as per section 170. These are the basic provisions, right? And we have discussed it already. So you know, when we are appointing a director, you as company secretary have been asked a question. So you will write all the provisions, whatever you have to check. Yeah, he has to hold DIN, he has to be eligible, and then he has to give you the consent declaration, then you will forward it to the registrar, blah, blah, whatever it is, right? So that is a general question, open question to you. You will have to refer to various sections and write the answers. It is very simple, right? So that was basically it. The questions that have been asked in your examination. There are some other questions that could be asked, right? That have been asked in your CS examinations or somewhere. So for other questions that can be put up apart from these topics, could be the question again on calculation, that the maximum number of directors are 15, you want to hire an additional director, what do you do? So you know you have to pass an SR, you'll have to amend your article and then appoint it. And then the power lies with the board, but nothing is provided in the article. So you know you'll have to refer to regulation 66 of table F. Right, over there you have been given the power. Right, so these are the other topics on which you could be asked questions. Right, so keep these things in mind, and then your entire topic is done. I hope it is very clear with you. In the next class, we'll cover up the casual vacancies. Right, so until then, this is Abhinay Gupta signing off. Stay tuned for the next lecture. Thank you. Bye-bye.